Good morning to all. Hope all are safe and healthy. I want to start today's day 4 session by a note of Nelson Mandela. It always seems impossible until it's done. I think all know session speaker Tyagaraja Gupta sir, Deputy Controller of Patents and Designs, Delhi, Chennai and Kolkata Patent Office. Sir, now you can go with your session, sir. You can continue with your session, sir.
Thank you, ma'am. Thank you. And good morning to everyone, and a warm welcome to this session and the series of sessions. And today's topic was given to me as the opposition proceedings in the patent office. Fine. Whenever I start with any topic, I should tell the relevant of the topic to your corresponding positions now. Otherwise, you will not have an attention towards the session, and you might feel, in what way am I going to be benefited by this particular session? First, you are in research. You have the intention of filing a patent application. See, the process is that this world is very big. You may not know what is happening at the other end of the same country. Someone else might also be taking the same sort of research area that you are involved in. And by chance, he might have filed a patent application earlier than you in the same domain. If that is the case, you have a chance to oppose that particular person from getting a patent. Or else, even if you're not at all involved in any research at all, you're completed that stage, still you can look at the patent office journal publications and see what are all the fields of inventions that are being filed for patent. And if at all, if you feel that some patent application is not a invention worthy of getting a patent, then as a general public, you could go and oppose the particular person from getting a patent for a irrelevant invention. Why? Because this filings of patent, we inside the patent office will look into the invention, and before granting a patent, we will decide all the three criteria of patentability, plus is it in the non-patentable invention, everything you will check before granting a patent. But still, the data is so large around the world, and we are also human inside the office. There might be a possibility that by oversight, we might miss some documents relevant to the invention, and without notice of it, we may grant a patent application for an invention which is not worth getting a patent. If that situation occurs, then as a general public, you are also given the onus to oppose a person from getting a patent for which he is not worthy of getting it. So as a general public, you too can take part in the patent proceedings and render your duty. So two aspects comes into picture. One, someone else in your own field has filed a patent document without your knowledge, you could come and oppose. Or else, you are not at all involved in this proceedings, but still you find someone else filing an application with an irrelevant invention. Still, you can come and oppose. For these purposes, patent system itself has got two modes of opposition proceedings. One second. Yeah. Whenever we need to start some sessions on patent, we have to show this slide only. You would have seen this slide n number of times, but still, no issue. I have to show you out. See, in the orange flowchart is showing one mode of an opposition, whereas the down in the blue and violet part is showing you the other mode of opposition. So in the patent system, we have got two modes of opposition. One, we call this as the pre-grant opposition or pre-grant representation. And the one that I show at the bottom is called the post-grant opposition, which by the name, you could assume pre-grant opposition, post-grant opposition. So the first thing is that you could oppose someone from getting a patent before a patent is awarded to him. That is pre-grant. And the post-grant opposition, the name clearly says that after a person is granted a patent, still you could go and oppose him. That the patent office has granted a patent to so and so person, but this grant of the patent is not legal. It should be revoked. that is called the post grant opposition. So a general public, any third party, I will not say general public, any third party here has got two options. One, to oppose someone from getting a patent before the patent is granted, and also to oppose the person who has got a patent stating that his invention is not a valid invention for awarding a patent. So two options are left with the general third party. Let us take each and every category and see what are the procedures, formalities, what is your benefit out of it, and in detail we will look each and every aspect of the pre-grant as well as the post-grant opposition proceedings. See, the patent system, not only the patent system, Indian patent system, almost every country's patent system has got this proposal of opposing the grant of patent by any third party. In the case of a pre-grant, the procedures are very simple. Why? Because patent has not been granted still. It's only in the processing stage. And so your way of application, the procedures, formalities, forms, fees involved in opposing at the pre-grant stage are very simple as compared to those formalities and procedures compared at the post-grant, because in the post-grant patent has already been granted. So there it has to be revoked, which is a bigger concept. So there the procedures and formalities which will be a bit complex and also time consuming. Still, why the post-grant is given is that by chance, if any third party has not noticed this publication, because you know in the patent system there are two publications. One, 18-month publication we call. You file a patent application. From that date, 18 months we wait, and at the expiry of the 18 months, we make one publication. That is called first publication or 18-month publication. If you feel that 18 months is too long, you could reduce that time by filing in Form 9 express publication, wherein within 4 weeks, maximum 1 month, we will publish your application. So from this date of publication, any person can file a pre-grant opposition. Till what time they can file? Till the date the controller grants a patent to that application. That is the deadline. Within this time duration, this window, when the application gets published, and to the time duration when it is getting granted, this is the first time window wherein the pre-grant can be filed. And if there are no formalities, no pre-grants, no any other issues, then the application goes for a grant. And the date on which the controller gives a grant, a certificate to that application, the procedure to file a pre-grant ends. So once a patent is granted to an application, it is again published. You know that it's a post-grant publication. Again, that publication takes place in the Patent Office Journal. From that date onwards, 1 year from the date of publication in the journal, 1 year from that date, the post-grant proceedings can be initiated. So any interested person, any person interested alone can file there. And all these pre-grant and post-grant are covered by sections 25(1) and 25(2) of the Patent Act. They help us in guiding how it should be proceed, what are the rules and procedures to be followed in cases of oppositions. They guide us. Yeah, we will look into the pre-grant first. This flowchart gives an outline as to what happens when someone is filing a pre-grant opposition. See, pre-grant can be filed only when two conditions are met. First, that particular application should have been published in the Patent Office Journal, either express publication or 18-month publication. Only then it will be noticed to the third parties. Only if they come to know about the filing of such an application, they can go for opposition if needed. So first condition, it should have been published. The second condition, the applicant should have filed a request for examination. We saw that Form 18, Form 1 and Form 18 are mandatory forms to be filed, and request for examination is Form 18. This is mandatory. Why? If the applicant has not at all filed the request for examination, then the Patent Office will not at all take up this application. And for 48 months we wait. If there is no request for examination, it is deemed to be withdrawn. When an application is deemed to be withdrawn, why should someone oppose it? There is no purpose in opposing an application which is not going to be granted. So we wait till the person files a request for examination. Only when the request for exemption is filed, it is gives us a meaning that this applicant is ready to proceed in this application and is interested in getting a patent. Then alone the pre-grant opposition starts. Fine. These two conditions we check, both are met. Then what happens? If you think that your friend has filed a patent application and that invention is not worth of getting a patent, and you could come and oppose. How could you oppose? You need to file a notice. That notice has got a specific form number called 7, for which you need not pay any fee at all. It is free. This opposition, pre-grant opposition, is free of cost. Also, any person can file a pre-grant opposition. No restrictions that only Indians should file, other nationals only should file. No restrictions at all. Any person who wants to oppose a person from getting a patent can file the pre-grant opposition. So no fee, no restrictions, and the form is form 7, or else even sometimes a plain paper request also sometimes are taken up for record. So it's so liberal. Pre-grants filing opposition is very liberal, very simple. Fine. You file a opposition. It comes to the patent office. As a controller, I receive it. Then I will read through your opposition and I will see to it under what reasons, under what grounds you are opposing this particular application. If there is some logic in that particular opposition which you have filed, we will take it up and we will proceed further. If there is no logic, if there is it's not meeting the requirements, then straight away the controller will ignore of that opposition by giving a reasoned order. Fine. We consider, we will take the situation that your opposition is valid and the controller is taking up your opposition. Then what should we do? What should we do is that the controller will convey this information to the applicant. Your opposition, your grounds, everything will be, a copy of it will be transferred to the applicant. The applicant is given 3 months time to read through your notice of opposition, to understand what you have mentioned there, and to give a reply for each and every grounds you have told in your opposition. He is given 3 months time. In the 3 months, he has to give back a reply, the response. If the applicant is not giving a response within 3 months, then naturally, without any proceedings, this application will be refused. If at all he is replying back in 3 months, then the controller will read through the reply also. Now you have filed opposition. It was sent to the applicant. Applicant has given a reply. Now the controller will read through the reply as well as the opposition. And if he feels everything is okay, he will give a decision. Or else, if he feels, if he needs some clarifications, he will call you both, the opponent party as well as the applicant, for a hearing. And he will give an opportunity to both the parties to present their oral arguments. The controller, if he has got any doubts, he will ask those doubts and get them clarified. And once the hearing procedure is over, normally the controller will take a month to decide upon what should be done in this application. And there are two parties, right? Here, one you, the opponent, the other the person who has filed the patent application. So two parties are involved. If the controller gives a decision, in any case, one party will get affected. If the affected party is not satisfied with the controller's decision, then he can naturally go for appeal to the higher forums. Earlier, there was Intellectual Property Appellate Board, which was the higher forum in case of the patent office concerned. But now this IPAB has been dissolved. So the applicants or the opponents have got the option to go only to the High Court, wherein in the High Court there is a special bench created to deal with IP cases related to patents, designs, trademarks, copyrights. All these issues are dealt with a special bench in the High Court, and you could go there and appeal against the decisions or orders of the controller if you are affected by that particular process. So this is a general overview of how a pre-grant is taking place. Now we will go into the intricacies. Okay. And I told you that section 25(1) takes care of the procedures of the pre-grant representation. And corresponding rule or rule 55(1) to 6 that states what should be done at what stage, what is the timeline, what is the form to be filed. And see, Rule 55.1 says that you could file a pre-grant under Section 25.1 only when the application is published and only when the request for examination in that particular application is filed. Second, the rule says that we should wait for a period of 6 months from the date of publication before granting a patent. Why is this? Why is this window of 6 months? I will tell you. See, let us take an example that on 1st of January 2021, you file an application for patent. And also, you have filed an express exam request for publication. So, 1st of February 2021, it has been published. And you also file a request for examination. Once the application is published and once the request for examination is filed, patent office will take up that application for examination. Say the patent office takes this application on 15th of February 2021. We examine it, we find everything is okay in your application, and it is we are ready to grant the application. And say, for example, by 1st of March 2021, we grant the application. So how long it took? Just 2 months, right? And from the publication, it took just 1 month. This 1 month period is so short. Any person who are following up that particular invention, even if he decided to file a pre-grant, within a period of 1 month, it would not have been possible for him to prepare those documents and file. So, yes, naturally, we should give him sufficient time after the publication taking place. If he wishes to contend through pre-grant, sufficient time has to be given to the opponent for preparing the documents, looking through the other grounds, and applying it to the patent office. So, sufficient time is needed. For that purpose, we give a window of 6 months. Even if your application is completely okay, we don't immediately grant. From the date of publication, we give 6 months period so that if any party wishes to oppose through pre-grant, they can oppose. Until the expiry of 6 months, there is no pre-grant filed. Then we will grant you the patent. Fine. That is what is told in Rule 55.1. A 6 months window after publication, we mandatorily give for persons who wish, if at all they want, they can file a pre-grant. And 55.2 says that request for examination is mandatory. And 55.3 says that once you file that opposition, this has to be sent to the applicant for him to read through it and give a reply. 3 months is told in 55.4. And finally, in 55.5 and 6, we say the guidelines for a controller, how to conduct a hearing. And after the hearing process, within 1 month, the process has to be finished off. Either he has to refuse the application for grant, or he has to refuse the he has to refuse the opposition. Third possible category is that he can ask the applicant to make some changes in his invention so that it is overcoming the opposition. So these three are the possibilities available at the end of the pre-grant representations, and these are guided by Section 25.1 and Rule 55.1 to 6. Fine. Can any person arbitrarily oppose any invention? Without any criteria, can he arbitrarily, by through his will, can he oppose? That's not possible. If you want to oppose somebody from getting a patent, there are some 11 clauses. We call it as 11 grounds. If the person whom you want to oppose, if his invention is falling in any one of these 11 grounds, only then you can make an opposition. Otherwise, you can't. So these grounds are important. If you want to oppose any person, you have to tell me under what grounds you are going to oppose somebody from getting a patent. So these 11 grounds are very important. In a nutshell, these are guided by Section 25A to K. And I will tell you 25A in a nutshell, it is called as when somebody has obtained his invention wrongfully, then you could oppose. And 25B says it's a prior publication. 25C says somebody has we are claiming. We will go into each and every grounds with an example so that you can easily understand. Now, just see them in a nutshell. And 25D says prior public use, prior public knowledge. 25E says lack of inventive step. Inventive step, you have heard about it lot many times. Again, it's a ground for opposition. And 25F says non-patentable invention. And section 3 is completely talking about non-patentable inventions. And section 25G says insufficiency of description. This is one valid ground where most of the individuals make a mistake. So I want to discuss in depth in this insufficiency of description, 25G. Then there are other four grounds: non-disclosure of information, time-barred applications, and biological material has not been disclosed, and traditional knowledge. So there are almost 11 grounds under which any person can oppose any other person getting a patent. Let us go into every grounds in detail now. As a first ground we have thought of is wrongfully obtained. Say, I will tell you a scenario wherein you, the researcher, along with a co-researcher B, A is a researcher and B is a co-researcher. Both are performing research in a particular field of invention. And what happens, they have been working on it for almost 1 year, and within a matter of 15-20 days, they are about to complete the research and come out with a viable solution for the problem they have taken it up. Now, what happens? B, the co-researcher, files a patent application for the research which they have been carrying out for almost 2 years without the knowledge of the researcher A. So he files an application under his own name for his research, and researcher A is following up with the patent office journals. And after a period of, say, express publication has been filed, after a month, he finds that B has filed a patent application for a research which they both have been doing jointly, wherein A's name is not appearing. So is A not affected here? Because both have done the research together, both have equally contributed on the research. Now B is taking credit of everything without A's knowledge. So what is the remedy left with A now? That is the first remedy. He could go and oppose B from getting a patent. Under what ground will A oppose? This is the first ground. He will say, sir, I have noticed that B has filed a patent application on so and so date, and it has been published in the patent office journal on so and so date. Now, I am opposing B from getting a patent through pre-grant opposition. So you will file a form 7. A will file a form 7. No fees, na? So he can easily file a form 7. Now the office will ask, under what grounds you say that B should not get a patent? For which A will quote section 25(1)(a), wrongfully obtained. That is the ground I am quoting from B getting a patent. Then the office will ask, okay, you say that it is wrongfully obtained by B. What is the evidence? We need some evidence, right? Then it is the mandatory requirement of A to show relevant evidences that B has wrongfully obtained the particular patent without the knowledge of A. What could be the possible evidences that A could submit in the patent office? He could show the complete data of research which A and B were taking together, that lab reports, any other statistical data, whatever data that A has with him, that he made a note of during the research he did along with B. Also, he could show that he is the true and first inventor in the particular research work, which A was not aware of. So some evidences, relevant evidences, lab data, research data, whichever says that A and B worked together on this particular project, such data should be submitted to the patent office as evidence to prove that B has wrongfully obtained. Then the controller will look into all those evidences submitted by A. And if the evidences are valid, then the patent office will notify B that he has wrongfully obtained this invention and we will not grant a patent to B. So this is one grounds wherein if there are multiple researchers in a particular field of invention, and if one files a patent application without the knowledge of the other, then the other aggrieved party can come and oppose the cheater from getting a patent certificate. This is the first ground. We'll move on to the second ground, called as sorry, moved off. Prior publication. See, this is a scenario wherein I file a patent application in India today in the field of communication, wherein my data is modulated, then it is encrypted, and it is transmitted to a second entity. This is what my invention is. And I make some important changes in the case of the encryption technology. That is where my prime research is. So that is what is filed in the patent application. Any person who are in the looking out similar fields, if he feels this encryption technology which I have filed is already known through some publication, some IEEE, I file it in say in 1st January 2021, and the same encryption technology is published in some IEEE magazines or journals on say December 2019, then that person can come to the patent office and oppose me from getting a patent for this encryption technology under this ground B, 1B ground, wherein he can state, sir, A has filed an application for encryption technology, but this encryption technology has already been published in so and so journal, so and so IEEE journal on so and so date, which date is earlier to the filing date of A. So this is known to the public before his filing itself. He is trying to claim advantage of a technology that is available in the public domain. So don't grant him a patent. This is the second ground in which any person can come and oppose any other applicant from getting a patent if that technology is available in the public prior publication, we call it as, in any public published document. It is available before his date of filing, then this ground can be utilized for opposition. But this ground is subject to the provisions of section 29. Let us not worry too much about section 29. It goes too much into the intricacies. Whenever you have the intention of filing a pre-grant, particularly under this ground 1B, only then you should worry about section 29. At this stage, I don't think we should ponder too much about section 29 and all. Let us ignore it and we will move on to the next round. And this is 1C, which is called prior claiming. This is typical applications in which you want to show reference of an Indian application itself to prevent someone from getting a patent. Here 4 conditions are mandatory, sir. If you are going to cite this prior claiming as the ground for opposition, 4 conditions are mandatory if you want to show. What are those 4 grounds? See, I have filed a patent application, say same technology, some encryption technology for data before transmission. And I claim this encryption technology as the claim number 1 in my application. And I have filed this application on, say, 1st January 2020. I have shown here. It is filed on 1st January 2020. Then naturally, I have not filed any Form 9. So 18 months it will take. And my application is getting published on 1st July 2021, 18 months after. So after publication, you come to know about this encryption technology. You make some search and you find one another patent application that was filed in India. And that application was published on 1st February 2020. See, I filed it on January 2020. But the document that you are showing me is published on February 2020, which is after my date of filing, right? But though this document is published on February 2020, this application was filed on August 18, 2018, 1st August of 2018, which is before my filing date. And in this document, the claim number 5 is relevant to what I have claimed in claim number 1. So here you could see 4 conditions. One claim in my application should be relevant to some other claim in some other application filed in India. Claim to claim matching filed in India. Say Third requirement is that it should have been published after my filing date. Fourth condition, it should have been having a priority date, a filing date before my priority date. So if these four conditions are met, then you could show me a document stating it is prior claiming. Sir, this encryption technology has been prior claimed in India itself by one another applicant, and that has been published after the filing date, but priority date is before my priority date of filing date. If these four conditions are met, then that document that you are going to show me is valid for a prior claim document, and it will be taken into record, and we will not give a patent to the particular person, citing this ground and citing that particular document you have shown me, which is meeting these conditions, these four conditions. We call this as a prior claiming. See, first condition, claim should be in one another claim. Second condition, it should be in India, filed in India. Third condition, it should have been published after my filing date. Fourth condition, the priority date should be before my filing date. If these four conditions are met, then you will take this ground of prior claiming. C ground. And this is the fourth ground. We call it as a prior use, publicly used in India. Say, for example, I have invented a methodology. With that methodology, I will be able to come out with a pen, the writing pen, that pen. This process, I found new process, I found out. With the application of this new process, I come out with a new pen. Now my application is for this process. But you, as a third party, find that the pen that is manufactured by the application of this process, which I am going to claim, is already available in India. The pen, the product pen, is already available in India. Though the process is not known, the product obtained by the process is the pen is already available as a product in India, and people are using it. Maybe it had been imported from some other country to India. Then you could come and oppose to my application of a pen manufacturing process under this ground, stating that he has filed his application on 1st January 2020, but the pen that is manufactured by this process is already in public use in India in 2019 itself. So this invention cannot be given a patent, and I'm opposing it under section 25(1)(d), calling it publicly known or publicly used in India. But one condition is there. This pen is available in India in 2019, but I filed it, the process application, I filed it only in 2020. But when I am able to prove that the pen was imported to India only for the reason of experimental purpose and trial purpose, not for sale, if I am able to prove that that particular class, then this ground does not stand valid for you to oppose. Hope you understand the grounds clearly. If at all, if you are not able to understand any of the grounds, if there are any ambiguities, please clarify it then and there. You could unmute yourself, you could ask me, or if you are not able to unmute, just type in the chat box, and I will clarify all your doubts. Don't wait till we complete the entire session. Then and there questions relevant to then and there subject will be more easier for you to understand. That's the reason. I don't have any objection of you interfering me. With the hope that till now, whatever I have told you, you clearly understand, I proceed further. Fine. This is the most important and very frequently used clause for opposition. That the invention is obvious to a person and it does not involve any inventive step. This is the predominant ground in my experience that most people utilize to oppose someone from getting a patent. And I do not know whether my previous speakers have talked about elaborate about the inventive step, how the patent office judges an inventive step obviousness in your invention or not. See, generally the Act 21J, we call it as section 21J, defines inventive step is a feature in your invention. What feature? It should have a feature which is technically advanced as compared to all the other documents in your field. or it should have an economic significance, or it both. This is what the inventive step is being explained in section 21J. But if I read through this sort of technical and legal parlances, it will be very difficult for you to understand. So I thought of giving you an example to explain you as how we people inside the patent office decide whether your invention has got an inventive step, whether it is non-obvious to a person skilled in that. Stay with me for another 3 or 4 slides wherein I will take real-time examples and show you how this technical advancement is judged inside the patent office. So what you are seeing in the slide is actually it is a digital scanner. If you could see here, this is the claimed invention with the serial number 24 to 58. This is what the applicant is claiming. See, people who are blind, how would they read the documents? They read it through Braille. Fine, it is a special made papers assisting the blind people to read through the document. But what if those people want to read the plain papers with the printed material, the normal paper that we have at hand? Will they be able to read those documents, the normal papers which normal people are reading now? What if they want to read that document which is not in Braille format? Is there any device to help them? This is the particular invention to help even the blind people to read normal documents. And if you could see here, at the place where the nib used to come, see the serial number 54. It is not a nib, it is a digital scanner. And 34, if you could see the serial number below there, it's a serial number 34, is a illuminating device. So a person who is blind can use this particular device. He can move this device on any normal printed paper. And this 54, once it touches the paper, right, it will get activated and this light will get illuminated. And immediately this pen will start scanning every information in the region that is illuminated by the light 34. And the data that is being scanned is being converted, the analog data is converted into the digital data, and this device has got a memory, it has got its own processors, and the data that is being scanned is being stored in this particular device. Okay, the normal text is now being scanned and it is being stored, but still the blind person will not be able to know the information. He should be having some mode to voice out the data that is being scanned. And if you could see here the serial number 24, this 24 is a speaker. Whatever data that is being scanned, digitized in the digital format, will be converted into audio. Text to voice software is being involved in this particular device, and it is being read out in the speaker through the speaker 24 incorporated in the device. And finally, the person will be able to hear whatever is being written on the paper. So the objective is being met here. Even the blind person can read through the document any normal person holds. Fine. Now, this is the invention, and this is what you have filed with the patent office. And inside the patent office, we will read through this invention in elaborate and understand what you have filed. After understanding your invention, what will we do is that we will make a prior art search and see, is there any other publications before your priority date or filing date available in the public media to disclose all the features of your invention. So here, what are the major features of your invention? It is a digital scanner. The digital scanner in the form of a nib, below which is an illuminating device. And once the scanner touches the paper, it gets activated. And the data is being scanned, stored as a text data. Then the text data, because it has got a USB port, can be connected to a mobile phone or to any other processors, and it could be transferred. Also, there is a speaker which will convert your text data into voice and will speak out. So these are the main features of your invention. We will make a list of all these features in your invention as a tabular column as a reference to us. Then for each and every feature, we will make a prior art search. See, for the first prior art that I get is this pen. This was filed and published before your filing. See, this pen is also has got a scanner here. This scanner will scan every detail in the normal paper. Also, this scanner, after scanning, will convert. It gets a memory here. It has got a processor here. It will get stored here. And you see, there is a Bluetooth option, and there is also a USB option to get connected to a cell phone or any other PCs. Also, you could see here. What else is there? See here, it says that it reads aloud the scanned text. Say, for example, let us assume that this particular document that I am showing you here has got a scanner which could scan things. It could store it. It could even transfer the data to any device as a cell phone or wireless PCs through USB or through Bluetooth connectivity. So every feature of your invention has been disclosed in this cited document, but only one is missing. What is that? This is not able to convert the text into voice, and there are no speaker to voice out. This is the only feature missing out, right? From your invention, this one feature is what is not disclosed in D1. All the other features are told in D1. So what we will do is that we will continue our search further to identify if there are any other document with this left out feature. Then if I am able to find a pen stand, this is a pen stand. The pen stand, the blue part, you could see at the bottom, blue part is a speaker that is connected through USB. This is the second document I get. This speaker will be able to convert the text into voice and will be able to voice out the data. Now I am getting two documents. One as such a scanner in the form of a pen, disclosing all the features of the invention except to one, no speaker. And I get one another document which is a pen stand, not a pen. Be clear, it's a pen stand, but with a speaker that could voice out the text being scanned. Now I show you both these documents, D1 and D2, and I will tell you that your invention is lacking inventive step, because your invention has got 5 features. D1 has got 4 features and D2 has got the 5th feature. So any person who is interested in coming out with a scanner, digital scanner in the form of a pen, can very well make out with the help of D2 the combination in the pen itself. So we cite these two documents to you and tell you that your invention is not having an inventive step. It is obvious to a person skilled in the art. I hope you are able to understand how we judge the inventive step or non-obviousness. Fine. I will show you one another example.
फर्स्ट फ्लोर पे
This is the second pen I'm showing you. See, it's again a pen, but it has a different application. What this pen does is that in this portion, there are sensors, multiple sensors. So if you place this pen in front of any product, any article, the sensors Hello, am I audible?
Yes, sir.
Yeah, please. Suddenly, I could receive that someone has muted me. That's why I was asking you this question.
Sir, I have muted the participants actually.
Oh, okay. I thought it was me. Okay, fine. So, okay, I will continue. And see, this is one another pen. This pen is able to replicate the color that is being scanned. This part has got a scanner. This scanner will sense the color of the product. The moment it senses the color, there are RGB inks in this pen, and the inks get automatically mixed to make a replica of the exact color that is being scanned. You could see this once the pen scanned this apple, the color of the apple got registered. The processor made a automatic mix of the three inks in the pen, and the moment you start writing it, the exact color of the apple got reproduced. So this is the invention you have made. This pen is what is your invention is. It's a scanner is there, a particular processor is there that receives the data from the scanner, and it instructs the RGB inks in the pen to proportionately get mixed to display out a color that is an exact replica of the product that is being scanned. If this is what your invention is, and you have filed with the patent office. Now, how we judge the inventive step or non-obviousness? We will tabulate all the features in your pen, and with those tabulation we will make a prior art search. And if I am able to get a first document, say for example, this is the first document I get. This is also a pen, and if you could see here, there are so many chambers inside the pen that could hold multiple inks, and also these chambers can be mixed manually to come out with a different colored ink. What colored we obtain is shown in the cap. This is the area where it shows, because of the mixing of multiple inks, what is the color you have finally obtained is shown here. And once you start writing, this color is getting replicated through the nib. So your invention and I find one another document very close to your invention. What is the difference between your invention and this pen that I have identified here? There could be two possible differences. One, there is no scanner here to scan the object. It is manually mixed. The inks are manually mixed. These are the two differences you could tell me from the earlier pen and this pen. So now what I will make is that I will take the document that I am showing you, I will name it as D1 and I will keep it aside. So what is not available in this document is the scanner. There is no sensors, there is no scanner. And the second aspect is that it is not mixing automatically, the mixing is manual. These two features are not available. Then I will continue my search further. If there are any other pens with this two features available, then I come out with this product, a diamond shaped product. You could see here. What this product does is that in this part of this product, there are sensors. If you place this product on any three-dimensional object, these sensors will scan the color of the product, this three-dimensional product, and it will be stored in the memory of the particular this diamond shaped product. And this product has got a USB connectivity, so that this will get connected to your system or your mobile phone, and this exact blue color which has been scanned will be stored in the PC. Now, can I club the earlier pen document with this diamond shaped scanner document and show you that your invention is not lack or is not inventive? No, I cannot do that. Why? Because your invention is in the field of a pen, but this document that I am showing you here is not a pen. Further, one feature that automatic mixing of the inks to give a replica is also not available. Since these two features are not available, I cannot show this document as well as the earlier document as under this clause of lacking inventive step. If these two are the only documents that I have in hand, then your invention will be judged as having an inventive step. It is non-obvious to a person skilled in the art, and your invention will go for a grant. I showed you two examples here. One, the digital scanner in the form of a pen. The other, exact replica of a ink which is scanned. The first case, I showed you two documents wherein all the features of the digital pen are being identified, based on which we adjudge that your invention is not having a technical advancement. Again, I showed you one another case wherein one or two features of invention I cannot find any document related to it. So I cannot say that your invention is not having an inventive step. This is how we judge whether your invention is having a technical advancement, inventive step, or not inside the patent office. Why have I elaborated so much on this particular ground is that out of 100 applications, 99 applications get refused under this ground. So before you file a application for patent, I want you to be double sure that your invention will not fall in this category. You yourself make a prior search, see all the documents, and make a judgment by yourself. And if you're 100% confidence that your invention is technically advanced as compared to all the available public documents, then the chances of you getting a patent is 99 percentage. That's why I am being dwelling so much on this particular class. It's a ground for opposition. It is a ground for refusal of your patent. This is a very valid ground. So you should, any person interested in filing an application for patent should know this ground in and out to have a higher chance of getting a patent. Fine. Then we'll move on to the next ground 1F, wherein it is said that we assume that your invention is an invention. No doubt about it, because it is meeting 21J. It is an invention, but still we don't give you a patent to it, or people can oppose it. Why? Because it is non-patentable under Section 3. I think most of the my earlier speakers would have talked in elaborate about this particular section. So I will move fast in this section with some relevant examples. Fine. The first ground is frivolous invention or invention contrary to well-established natural laws. Say, for example, I come out with one particular machine, and I say, my machine, you need not give input continuously to this machine. First, for a first few seconds, I give input, then I remove off the input from the machine, and this machine will, irrespective time duration, will keep on giving me the output. So the efficiency of my machine is more than 100%. If I say so, will you accept it? Because it is well established that no device can have an efficiency greater than 100%. And if this machine says that it is overcoming this particular natural law, we will not accept it. There should be some flaw in your invention to say so. So under this ground, we will not be given a patent for the invention. This is one ground for opposition also. And the second ground, say it is contrary to public order or morality. I'll give you a simple case. See, I come out with a key to open the locks, but this key is a universal key. It can open any lock in the world. It is a piece of metallic strip that I have come out, that I have connected with some scanners and a corresponding processors, and it is a liquid metal, so that it can rearrange itself. The moment I insert this liquid metal into a lock, the scanner will sense the inside features of the lock, and depending upon the scanned features, my liquid key will rearrange itself to fit exactly with the lock. This is my invention, and I filed for a patent application. Do you think this application can be given a patent first of all? If not, why? Will this lock not help in theft? When a key is able to open any lock in the world, will it not help the burglars? Will it not create public morality orders issues? So even if this is an invention, we will not give a patent. Also, under this ground, you can oppose the other person trying to get a patent. And if your invention is causing some serious prejudices to the health of human, animal, or plant life and to the environment. See, I'll give you one example. This is a real-time example happened in US. People are prevented from smoking cigarettes? What's the reason? Why are we prevented from smoking cigarettes? The reason is that the nicotine in cigarette will enter our body, and once the nicotine enters our body, there are chances of we getting cancer. That's the reason we are prevented from smoking cigarettes. But what if I come out with a cigarette that will filter the nicotine from entering my body? See, I have found out the problem. Problem is nicotine entering my body causing cancer. So what is the solution? I must do something in the cigarette that should prevent the nicotine from entering my body. That is a solution. Okay. What is the way of implementing the solution? So people have done lots of research on this domain, and they came out that cheese, you would have heard the normal cooking, we use cheese. Na? One variety of cheese has got the ability to prevent nicotine. It is acting as a filter for nicotine. That is what the research has found. So immediately what they did is that they took a specific ratio of that particular cheese, and you could see the serial number 4 here, and inserted it in the bud of the cigarette, so that it acts as a filter to nicotine from entering our body. So they implemented it in the cigarette, and they tried it out. So they lit the cigarette and it started to burn. As anyone knew the burning smell of cheese, it will be very horrible. Something like a rotten egg smell you get. When cheese gets burned, you get the smell of a rotten egg. And if you place such a cheese in the cigarette, and if you light the cigarette, cheese will automatically get burnt, and you will get a rotten smell out of the cigarette. When a cigarette is giving rotten egg smell, can anyone smoke it? And that too, placing it near your nose. Absolutely, you cannot. So I told a problem, I told a solution. When that solution was implemented in the cigarette, one another problem is coming out. A rotten egg smell because of the burning of cheese. So what is the solution for this problem? Again, the research was continued, and they found out that charcoal has got the ability to absorb this pungent smell or rotten egg smell coming out of the burning of cheese. So this is the solution for the second problem. So what they did is that they took some ratio of this charcoal to a corresponding ratio of the cheese. They mixed it, trial and error versions. They kept in the butt of the cigarette. You could see now serial number 4 is the cheese and serial number 6 is the charcoal. A particular proportion of the charcoal cheese combination was inserted in the butt of the cigarette. And now when you light the cigarette, the cheese filters the nicotine, and the bad smell coming out of the cheese is filtered by the charcoal. And this cigarette was able to give you a wonderful effect wherein no nicotine was entering the human body. Don't you think this is a beautiful invention? You could, even you smoke cigarette, you don't get cancer. Is this not a beautiful invention? Yes, this is a beautiful invention. And this was given a patent in US. But in India, this was refused. Why? The earlier ground I told you now, any invention that is causing serious prejudice to the health of plant, animal, or human, or to the environment. Under that grounds, this invention was refused a patent. Now, one question should come to your mind if you're seriously following my session. Sir, this cigarette, how it is causing serious prejudice to the health? When this it is able to filter the nicotine, where is the prejudice to my health? That question should come to your mind. Then how could you use section 3B to refuse a patent? If that question comes to your mind, then you're seriously following my session. See, the reason here, quoting 3B, is that not the smoker's health is getting affected. The smoker's health is not getting affected by this cigarette. But passive smoking, it releases out so many smoke from the cigarette, right? The person standing next to him will naturally inhale that smoke. That smoke will cause, as a passive smoker, will get affected. For that reason, this cigarette was refused a patent. And this is one ground for opposition also. So what happened? I will show you one another case. I do not know how many of you are able to understand this particular picture. It is actually a hat to be worn by the cigarette smoker. You could see here now in this place, this is the mouth of the person smoking the cigarette, and this is the cigarette, and this is a hat to be worn by the cigarette smoker. What happens is that the smoke coming out of the cigarette is being sucked in by one particular chamber in this hat, and this smoke goes into a second chamber where it is being purified, and the subsequent levels of purifications take place here, and finally here the purified air, which is void of any hazardous material, is liberated out into the atmosphere. So this is a hat for the cigarette smokers to help the passive smokers from getting affected. Now what I do, the earlier cigarette I showed you, which was refused under 3B, stating passive smoking will be caused, and I club this hat. I club this hat with the cigarette and file an application for patent. Now, can I, as a controller, refuse the cigarette under Section 3B? No. So this is how people keep on continuing their research. See, from one problem they came to a one solution. In the implementation of the solution, they found out a different problem. For that problem, they again performed their research and came out with a viable solution. And when it was applied for a patent office cited one another problem. And for that particular problem, a smoker's hat came into picture. Now, the company is selling such sort of cigarettes in US along with this hat, and it's a huge market there. They are earning in millions and millions of dollars because it was patent protected. So what I want to say you here is, for every problem there will be a solution, and for every solution there will be a problem. This is a non-stop process. When you keep continuing a research for each and every problem that you encounter, at the end of the day you will have a beautiful product with excessive market for it, and once that is protected for 20 years, your life is settled. Not for 20 years, even after 20 years you would have earned sufficient amount for your lifetime. Your life is settled. This has happened in US with respect to a simple cigarette. That's what I wanted to convey you here. So one thing that I want to tell you is that grounds for opposition is 3B. Also, there are so many options available for you to overcome that grounds. I'll move fast. And mere discovery of a scientific principle, we don't give you a patent, because inventions are granted only for innovations, not for mere discovery. Discovery means that is already existing. Nobody knows it is existing. You found out it is existing. That doesn't have any technical knowledge, technical application of the mind. So discoveries don't come into the purview of patenting at all. Then the Section 3D, which is a gray area, very unique to Indian Patent Office. As an engineers, let us not worry too much about 3D. It's only for the chemist pharma area. But I'll simply tell you one example. See, aspirin, the pharmaceutical combination in aspirin, you know, it is already protected by patent. Now, aspirin is used for curing your headaches. Now, what happened? Some other person doing research on the same pharmaceutical composition, he comes out that the same composition is now able to cure heart attack. There is no change in composition, same composition of the tablet, aspirin only. Earlier, we found out, one person A found out it is treating headaches. Now the B is finding out the same composition is treating cardiovascular disease. Can B file an application for the same aspirin tablet? See, I have found a new use. It is acting as a blood thinner. When someone is affected by heart attack, if he takes one tablet of aspirin, immediately his blood becomes thin and he will be relieved from the heart attack. As a first aid, you can take as aspirin, is what I found out. Can I apply a patent? You can apply, but we will refuse your application under Section 3D, telling aspirin is already known, aspirin has already been patented, and same composition only you are also again claiming, but only the use is differing. The earlier person told it is for headache, now you are telling it for heart attacks. So new use of a known product, we don't give patent under Section 3D. At this stage, let 3D be known to this extent alone. Fine, that's next one as a mere admixture. See, this class comes predominantly to inventions relating to food. one homemaker. She's called, the name is appearing here, Shubhangini Patel. She found out a new soup. That soup has a combination of unique ragi and walnut. And the ragi is the finger millet ragi. So she has come out with a new soup. That soup has the composition of a finger millet and walnut. And this soup is acting as a substituent for non-vegetarian people. If you are not allowed to eat non-vegetarian, if you want to have the equivalent substituents in your body, then you could take this soup. This is what the invention is. She has filed it. But this invention was opposed under this section. What this section says is that we don't have any problem in giving you a soup, but ragi has got some effect. Walnut has got some effect. Say the effect of ragi is A and the effect of walnut is B. Now you have combined ragi and walnut and you have come out with a soup. Is this soup giving me any effect that is greater than the combination of ragi and walnut? Say simply A from ragi's effect I have got, B from walnut's effect I have got. I combine A plus B and I get A plus B. Now I will subject your soup to again subsequent test. And if the soup is giving me an effect that is greater than A plus B, only then your invention, the soup invention, will be granted a patent, overcoming this objection 3E, near admixture. If I find the same effect of the walnut, same effect of the ragi only is found in the soup also, no additional effect in the soup, then we will cite this section 3E and we will not grant you a patent. And this is one ground for opposition also. If you file this soup for patent, and any person can come and oppose the grant of a patent to the soup, they could quote this ground. Fine. And plants and animals, they are not given a patent. They are all living beings. So living being cannot be given a patent under section 3J. But there was a one exception to this case. Genetically modified microorganisms. Microorganisms, though animal, living animal. If it is a genetically modified microorganisms, then they are given a patent. There was a beautiful case study behind this particular section, and amendment in this section. I will tell you. It's getting what's the time? 10:15, but still okay. No issues in telling you this case study. What Indian scientist? His name is called Anando Chakrabarti. He's a biotechnologist. He was doing lots of research, and he found out one particular microorganism, a bacteria or an algae. I think it's an algae, and he was doing research on that algae, and he was able to modify a particular gene in that particular algae, because of which modification of the gene, that algae developed a new characteristics. What is that? That algae developed a characteristic that if you put that algae in any hydrocarbon containing liquid, this algae could break that hydrocarbon into hydrogen and carbon. This was his invention. And naturally existing algae, he took that algae, did lots of research on that, and finally identified that if you are genetically modified, one gene of that particular algae is modified, then a new characteristic is coming to that algae, which helps it to break the hydrocarbons. This algae had a beautiful application. Recently, you could have heard that in the Indian Chennai port, one ship that was containing the petrochemical products got broke down, and all the petroleum products were leaked into the sea. And what did the government do then to clean the sea? You know that. And this invention is of timely help at that time. This algae, if it is sown in that sea where the petrochemical products were spilled, then what is the predominant composition of petrochemical products? Hydrogen and carbon, right? But in a complex manner. So this algae was able to break down that complex hydrogen and carbon combinations. Once hydrogen and carbon gets broken down, it's a gas. They naturally get evaporated out. So petrochemical products that were spilled in the sea can easily be cleaned out. So that was a beautiful application of our Ananda Chakrabarti's invention. So till that time, they were not giving a patent for animals and plants. But once this invention came out, though it is an animal, algae is can be classified as an animal only, but a genetically modified um, organism, microorganism, specifically to microorganism, they gave an exception. They made an amendment to the clause and gave that such genetically modified microorganisms is what your invention is, then it will not fall under section 3J. We will give you a patent if it is meeting the novelty, inventorship, and industrial applicability. So this is a beautiful invention done by our Indian inventor researcher, wherein even the clause section itself was got amended because of his beautiful invention. So I want you people to use such sort of Anuj Chakraborty as your source of inspiration, come out with bigger and bigger innovations that is going to straight away help the general public at large. Not only that, you will also have enormous fame, also millions and millions of dollars in return for you, the research that you have done. So that is a moral satisfaction you get. I have taken so much of resources from this society. What have I contributed back to the society? That's a moral question each and every person should ask. And if you are able to come out with such beautiful innovations, then you are contributing back something to the society. You are solving the problems of the people in the society, for which you get fame, you become fame, also you get monetary benefit in return. So patent helps you out in so many aspects, and this is one ground where people can oppose you also. I'll move on. The mere arrangement, rearrangement in engineering innovations, this ground frequently comes into picture. What I say is that I'll show the next example. That will be much more easier for you to understand. See here, first case you see, if the person wants to apply some medicine to his eyes, the same person applying medicine to his eyes will be a bit difficult. So there, this invention has come to picture. A spectacle with a hole at the center wherein a funnel has been connected, and now the same person can apply the drops to his eyes. It is an invention, no doubt about it, but this falls under section 3F. It's a mere arrangement. See, the cone can act independently, the spectacle can act independently. Now those two have been clubbed together. That's all. What is technically advanced here? What is the concept you have applied here is nothing. It's a mere arrangement. Also, you could see on the right, the glue sticks are already available. You know that. Now you replace the glue inside the stick with a butter, and it is becoming easy for you to apply the butter on the bread. If you say that this stick is my invention, it is an invention, but still it falls under section 3 of mere arrangement. You replace the adhesive with a butter. So we don't grant you a patent, and one ground for opposition. See, this is a helmet used as a bar. If you could see, there are 4 containers. This, my arrow indicates 1, 2, 3, and 4 containers. This container has got, say, for example, rum. This container has got vodka. This container has got water. This container has got some juice. Now, the person wearing this hat, by pressing the combinations of these buttons here, can have vodka mixed with fruit juice, and it will be delivered out through this pipe to his mouth. Or if he presses this button, then rum will get mixed with fruit juice, and it will get delivered to his mouth. If you come out with this invention, can it be granted a patent? Though it is an invention, sir, I need not go to a bar to ask for this combination of my preference. I can mix myself and drink. This is an invention. If you say, okay, we will accept this to be an invention, but this is a mere arrangement. So 4 containers with some pipes, you have arranged it, and that combination coming to your mouth, we don't say this has to be a patentable invention. But we don't give a patent under this in category. Then you have this 3K. 2 thumb rules are there. Business method, mathematical method, computer program per se, algorithms. If your invention is in any one of these 4 categories, then we say it is a non-patentable invention. To overcome this objection, we have to show us 2 things. One, though your invention is making use of a computer program, it is having a technical effect, a technical character, a technical advancement. Whatever you call it is all one and the same. Technical effect or technical character, technical advancement. You have to show me that your program is having such an effect which is implemented. Second, that your program is tied up with a hardware. If you are able to show me these two rules and these two thumb rules, if you are able to meet, then section 3K can be overcome and it will be granted a patent and one ground for opposition. And most of the inventions coming in the field of computer science, they get caught here. And this is one example wherein your invention is only with respect to a argument model. This is what your invention is. What this argument model does is that your source code you feed to this argument model. This argument model will check your source code, and if there are any vulnerabilities in your source code, this argument model will display out in the screen, computer screen, stating at the line number 10 of your source code has got some vulnerability, line number 25 has got some vulnerability. So try to rectify all those vulnerabilities in your source code is what this invention will tell. What is this invention? Typically, it is only at software. Nothing apart from the software is in this particular invention. So if you remove this argument model, then there is no invention at all. Argument model is only a software. Then this class 3K will come into picture, and your invention will be refused a patent. Fine, then we will move on. 3H is a method of agriculture or horticulture will not be given a patent because there is separate separate criteria. Plant variety protection is a separate criteria there through which you could protect. But if you come out with a tractor, the tractor will help in performing in agriculture, then the tractor is patentable, but not the method of agriculture is patentable. Then any surgical process are not given a patent. Why? The first reason is that this is not having any industrial applicability, because three grounds I told you, novelty, inventorship, and industrial applicability are mandatory grounds for any invention to get a patent. A surgical process does not have any industrial applicability, so we don't give. Second reason is that, see, a doctor is coming out with a new surgical process of treating a heart block, and if suppose he is getting a patent for that surgical methodology, what happens? He owns the ownership of that particular surgical methodology. No one else in the world can do that surgery without the doctor's permission. Suppose today someone is having a heart attack, he is in the case of emergency, he has to be underwent that particular surgery. Can the person go and keep talking with the patent holder, please give me permission to perform your patented methodology? By the time the patient would have been gone. So it poses serious health risks to the public at large. That's why the government of India has put all surgical, medicinal, prophylactic, diagnostic, therapeutic processes in the field of pharma, whether it is in vitro or in vivo. If it is a methodology to render someone free of diseases, though it is an invention, we don't give a patent because it might affect somebody's health, life at one instance. So it should not go into the patent protection and all. It should be in public domain only. Then method of playing a game or method of teaching a scheme or performing mental act. Simple, I give you one example. See, I devise a methodology to play chess. I say first step is A, you have to move this coin. Second step is B, you have to move this coin or this coin. Like that, I devise one strategy. And if you follow my strategy, I am 100% sure that no one can beat you in the chess. This is my invention, a methodology wherein 100% success in winning the game of playing chess. This is a new invention only because no one till date has found out this methodology of playing chess. Can I apply a patent and get a patent? No, because this is a mental act wherein no technicalities are involved, so we don't give a patent. And this is a ground for opposition also. Then presentation of information. I design a new website. The website is having so many informations on it. That information is all of mine. The design of the website is also my creativity. And now I ask you to give me a patent protection for that website with so much of information, creative information loaded on the particular website. Again, though it is innovative, we don't give a patent stating it is only presentation of information on the website, nothing else. And if someone else is applying for such websites, you could come and oppose him getting a patent stating this particular ground. And literary, dramatic, musical works, they go under copyrights. Integrated circuits is what your invention is. They go under separate act is there. Protection of ICs, it goes there. Then traditional knowledge. And you would have heard about cases dealing with the turmeric, neem, basmati. US people, EP, European people have taken advantage of it. They obtained patents of such turmeric, neem, basmati rice, and all. Then our Indian government, with the help of CSIR, they took initiative and fought legally at US and EP and tried to obtain nullification or revocation of the patents in those countries. I think you would have heard of all those stories. And once such a thing happened, then Indian government thought that okay, these are all our traditional knowledge. We have been using it from ancestors after ancestors, and since it has not been recorded, people from other countries are making advantage of it. So they Indian government took an initiative and they developed a traditional knowledge digital library, and those knowledge which was in the form of a pamphlets, which was all in the form of the, we call it as what do you call the ஓலை சுவடிகள் அப்படின்னு சொல்லுவோம் இல்லையா, all those information in those steps were all scanned, digitized, and a library, digital library was created. We call it as TKDL, traditional knowledge digital library. Now all this traditional knowledge have been digitized now, and in the digital library anyone can access and see such information. And if your invention is making advantage of any such of the traditional knowledge, then we don't give a patent and one ground for opposition. So now we will move further, and this is the third most important ground where people like us, an individual, feed a prey, fall a prey. Do not sufficiently disclose the invention. What happens is that, see, as a researcher, you want to publish some paper in IEEE proceedings. So you start drafting the application, right? Drafting the paper. There is a fixed procedure for IEEE. In this format only, your paper has to be written, right? Only if you write in that particular format, IEEE, though yours is a beautiful research work, if it is not written in their specified format, it will not be taken up for publication in IEEE or take up for any journal, Scopus or any journal. Similarly, the patent application also needs to be written in a specific format. And the most important methodology is told in section 10.4 as to how you should draft a patent specification, in which one important criteria is that you should give the best method of performing your invention. See, I have one problem. I tried to solve that problem through my research. I come out with one first model. Then I continued with my research for the same problem and came out with a second model. Which model is more efficient than the first model? Then I continued further and came out with a third model which is efficient than the first two models. Now I have three solutions, three models for the same problem. Now, when you are about to draft a patent application, all the three models should be explained. And finally, you should say that the third model is the best model for performing the invention. And there should not be any lacunae in your drafting. Right from step A till step Z, every step has to be explained in elaborate, and it has to be filed. Finally, the specification should have a part called claims. This is the legal aspect of the technical invention. Claims, I think my subsequent speakers will tell you as to how a claim has to be drafted. So take that also into your mind. Specification and the end should have a claim. Both the specification and the claim should be properly drafted. If it is not drafted properly, then section 10.4 will come into picture, or section 25G will come into picture, and your invention, though acclaimed as an invention, may not be given a patent. I will give conditions inside the patent office, how a controller judges whether your invention is properly drafted or not. First, I will tell you, you have come out with your research. Research is over. You have also made a specification, patent specification. you have finished writing every nook and corner aspects of your invention research in the patent specification, and you feel it is perfect, complete. What we suggest you is that you take the help of one another researcher in your own field on which you can depend upon. You give your completed paper to him, ask him to read the write up what you have done, and then ask him to explain whatever you have written without seeing the write up. If the your co-researcher or the person whom you have taken help of is able to come out with all the points that you thought of in your mind, then your research paper or the complete specification that you have written is perfect, meeting the grounds of section 25G as well as 10.4. That is one simple methodology where you can ascertain your written specification is complete or not. Inside the patent office, how will we check this particular ground? The controller will ask two questions to him. Upon reading the specification, will any person working in the same field able to implement this invention without your help, the applicant's help? If the answer is yes to this question, then it meets this criteria. Also, the controller will ask another question: is every aspects of the invention described? Is there any unanswered questions lying in this specification? If there are any unanswered questions, then your invention is not complete. If all the questions which the controller thinks relevant to your application are answered, then this application is meeting section 10.5 as well as section 25G. I have told you three most important grounds wherein 99% of the applications are being refused or being opposed. First ground, lack of inventive step or obviously a person's skilled in art. This is the first ground. Second ground, section 3, non-patentable invention. The third ground is this section 10.5 or 25G. 99% of the applications are falling only in these three grounds. And if you are able to come out with your invention that is overcoming these three grounds, then 100% I'm sure you will get a patent for your research work. And there are some other grounds which is telling that if you are filing an application, corresponding application in a foreign country, then every 6 months you should intimate the home country about the status in the foreign country of the same application. If you are not disclosing, then this is one ground for opposition wherein your granted patent can also be revoked. Then false disclosure. Maybe sometimes in US your application would have been refused, but you show to the Indian patent office that it has been granted in US. It's a false disclosure. This false information will make revocation of your revocation or post grant or pre grant. So many grounds. These are all common grounds. So many criteria. Then the time limit within 12 months. You know, if you want to make a foreign application, you file an application in India, and it's a home country where you file an application. It's a priority application. Within 12 months from the filing of the priority application, you should decide in which countries you have to make a corresponding foreign applications. Either you can make use of the conventional application specification mode, or you could make use of the PCT mode. Two options left with you. It is up to you to choose the conventional mode or the PCT mode. And time duration is only 12 months from the date of filing in the home country, within which you should have gone for the conventional application or the PCT application. And the last two is that if your invention is related to some biotechnology or biomedical, then you are making use of any biological material, then from where did that biological material sourced should be disclosed. And finally, the traditional knowledge that I told you. These are all 11 grounds under which any person can oppose any other person from getting a patent in pre-grant. Fine. And now I have come to the end of the pre-grant procedures. In a nutshell, I will tell how to oppose in pre-grant. Form 7A that is available in the IP India site. You could use it for opposition. And along with Form 7A, you should tell under what grounds. I showed you 11 grounds now. Under what grounds you are opposing. And if you have mentioned it as one ground, then you should give us the evidence for that ground. If you say that it is clear publication, that this invention has already been published in IEEE journal before you are filing, then I need a copy of the IEEE journal. That is the evidence. So Form 7A, the grounds on which you are opposing, plus the evidence for the grounds. This is what you should file with the patent office to oppose. So once you file an opposition, a pre-grant opposition, the controller will look into the grounds as well as the evidence you have filed for the grounds. If those evidences are all valid, then me as a controller will send those grounds as well as the evidences to the patent applicant. He will be given 3 months time to read through all your evidences, all your grounds, to reply back. 3 months time. If he is able to reply back in 3 months, then his reply statement will also be taken into consideration. I will read that reply, and if at all necessary, I will call you as the opponent. I will call the other party who is the patent applicant. Both the person will be, nowadays it's all video conferencing, will be called over VC on a particular date, and both the people will be given an opportunity to share your ideas. Depending upon your arguments, the controller usually take not more than 1 month to come out with a decision. The decision will usually be in these three categories. Either he can ignore your opposition if it is not properly in proper grounds and allow the patent to proceed further and give a patent certificate for him, or he can refuse the grant of a patent based on your opposition. Or the third class, he can ask the patent applicant to make some important changes in his application so that it overcomes the grounds on which you have opposed. So three possibilities are left out to the controller in deciding upon any opposition case: grant or refuse, or make some changes in the application and then grant. In all three categories, one party will be affected. If I grant the patent application, the opponent will get affected. If I refuse the patent application, the patent applicant will get affected. If I make some amendments in the patent application and then grant, again the opponent may get affected. In any situation, one party will get affected. That is default. Now what happens? The affected party can go for appeal with IPAB against the controller's decision. I am not satisfied with the controller's decision. Please, you being a higher forum, give me a probable remedy for me. So that option is available to you. Patent office is not the final ultimate authority. So there are so many high courts, Supreme Court, so many higher authorities are there where you can challenge the decisions of the controller. Fine. And this is one statistical data showing the number of patent applications published and the corresponding number of applications that are being opposed. You see, in 2017-18, from 13 to 18, not even 1% of the applications that are published are opposed. That is the awareness with the third parties regarding opposition. But when you come to the last 2 years, 18, 19, 19, 20, there has been a huge increase. 800 oppositions have been filed. So slowly, this awareness has come into picture. People are now utilizing these provisions in the Patent Act, and they are trying to say their power. It is a power given to the every individual, every citizens of India. They are now utilizing this power and opposing the grant of patent to any invention that is not worth getting a patent. See, 800 oppositions have been filed in 1920 itself. So to see how awareness has started to come up, how people, because there is no fee involved, it's just free of cost. So, and also any person can file, no restrictions. So people are trying to utilize this opportunity given by the government of India so that they avoid any unworthy inventions from getting a patent. Fine. And I will tell you one case law wherein how the companies fight among themselves in the pre-grant opposition. See, there are, you would have already heard about water purifiers. Purit is a company very popularly being advertised in the media also. You know which company is manufacturing Purit? Hindustan Unilever. What happened is that Tata Chemicals, and they, along with the Tata Consultancy Limited, TCS, together, they ventured into the water purifier domain, and they made lots of research, and they came out with a beautiful water purifier. They tried to protect that water purifier and wanted to sell that water purifier under the brand Tata Swatch. This happened in the year 2008. Once Tata Chemicals filed an application for patent for their water purifier, naturally it was published. And once something is published, the competitor companies will always keep looking at the patent publications, and they will make a note if any of the companies are making any product similar to their marketed products. And if such products are being made, they will try to their level best to oppose the competitor company from getting a patent and releasing that particular product into the market, so that his market is not getting affected. So Hindustan Unilever, who has already got a water purifier under Purit, when he comes to know about Tata Chemicals also venturing into water purifier industry, will he be silent? No. So what Hindustan Unilever did is that he filed a pre-grant opposition on 2011 January, stating that the application filed by Tata Chemicals for a water purifier is not having so many grounds. I told you, 11 grounds. Under the 11 grounds, 2 grounds were cited. Under those 2 grounds, you should not give a patent to Tata Chemicals. Fine. Before going into the grounds of that Hindustan Unilever, in a gist, I will tell you what is the invention by Tata Chemicals. It is a water purifier wherein there is a water storage chamber is there, and another 2 chambers which sucks the water from the water storage area, purifies it, and eliminates out the unwanted water and stores the purified water. This purified water is outputted through a specific walls. This is what is being claimed by Tata Chemicals. Now, Hindustan Unilever opposed under these 2 grounds, clear claiming ground and lack of inventive step, for which they cited several documents stating that all the features of Tata Chemicals is there in the previous documents. Clear claiming, I told it should have been filed in India. 4 conditions I told you. Filed in India, the claim of Tata Chemicals should be in the claim of some other. Here in this case, it was Hindustan Unilever's case itself. So 4 conditions for clear claiming, they told all the 4 conditions were met. And it the controller took up this case. He went through the grounds of opposition by Hindustan Unilever pre-grant representation. He looked into the evidences filed by Hindustan Unilever for clear claiming and lacking inventive step. He read through those documents, and also he found out these documents are relevant. And what is the only feature that is available in Tata Chemicals is that the nozzle that is outletting the purified water has been changed, and this change is only an aesthetic change. There's nothing technical change. Is the only feature that is available in Tata Chemicals water purifier as compared to all the other documents available in the art. So the controller was also of the opinion that Tata Chemicals that Swatch branded water purifier is not having any inventive step. So but to be on the safer side, before giving any adverse decisions, the controllers will usually give an opportunity for both the parties to voice out their arguments. So an hearing was offered. Hindustan Unilever as well as Tata Chemicals, both the parties took part in the hearing, and both the parties presented their arguments. And Tata Chemicals was not able to give any argument to meet this objection that only an aesthetic change in the nozzle is the invention. All other features are already claimed, clear claiming and inventive step. So Tata Chemicals was also not able to give any argument to overcome this objection. Finally, the controller decided that Tata Chemicals application of Tata Swatch water purifier has no inventive step. Though it is novel, it does not have an inventive step. And this opposition by Hindustan Unilever was taken into record. Based on this opposition, Tata Chemicals was not given a patent. This is one case law which I want to tell you, that even before somebody getting a patent, you could refuse him through pre-grant and avoid him from getting a patent at all. Now, Hindustan Unilever is the only company with the Purit for 20 years. There is no competitor for him. So, full market of water purifier is with the Hindustan Unilever, no competitor at all. Had Tata Chemicals come into the market, it would have affected Hindustan Unilever. See, Hindustan Unilever has utilized the provisions, opposition provision, and they have wiped out their competitor from the water purifier industry itself. So no Tata Chemicals has left this industry of water purifier. Power of pre-grant opposition, they wanted to convey you here. And this is one another case wherein this is dealing with Virgin Atlantics. Is airways, you know that Virgin Atlantic is an airway. They filed a application in India. It's a national face application filed in some other foreign country through PCT. It has entered India in 2004. What this invention is that it is a passenger seat. In the aircrafts, you find the passenger seat, right? And for long duration travel, those 20 hours or 14 hours, if you want to travel in an aircraft, those seats are not convenient for the passengers. For 14 hours, it gives you backaches. That was the scenario in 2004. So Virgin Atlantic came out with a passenger seat used in aircrafts. Even for 14 hours, if you continuously sit in that particular chair, it will not give you any backaches. It was ergonomically designed to suit the spinal cords of each and every person. That is the invention by Virgin Atlantic. Now, what happened? It was filed in India in 2004. In 2007, Jet Airways filed a pre-grant opposition under Section 25(1). And if you see the grounds, obviousness, lacking technical advancement, and the prior anticipation, prior publication. These are the two grounds under which Jet Airways filed a pre-grant opposition, stating that this seat by Virgin Atlantic is not technically advanced, and this is already published in some other document before 2004 itself. And based on this opposition, see, I told you that opposition proceedings can be filed at any time before the grant of patent. When Jet Airways filed this opposition, Patent Office has already examined this application and they have issued a first examination report to Virgin Atlantics. After the issue of the first examination report only, this Jet Airways has filed an opposition. Now, what the Patent Office did is that, along with the first examination report, we sent one another communication to the Virgin Atlantics that Jet Airways has filed opposition. Now, based on this grounds of opposition, Virgin Atlantics amended their application. They changed some features in their seat so that it is overcoming this grounds of anticipation and obviousness. And they refiled their new case of seats. Based on the new seat modification they did, now Jet Airways filed one another document to anticipate the modification that was done on the seat. So this was again by Jet Airways taken into record, and the controller now gave an opportunity to both the people. And based on the hearing, what the controller found is that Jet Airways cited some new document to anticipate that the amended seat of Virgin Atlantics is also not new, but that is not the case. The controller, after scrutiny, found Jet Airways citations are not to the mark to anticipate or kill the inventive step of Virgin Atlantics. So the pre-grant was refused. Once the pre-grant by Jet Airways was refused, immediately in 2010, Contour Aerospace, they are one European-based airline company, they filed a second pre-grant representation for this application. So the once one pre-grant was dismissed off, see, some other company has filed a second pre-grant for the same invention. Now again, all the procedures of a pre-grant has to be followed with the second opponent. We have to obtain the statements, is evidences, look into that by Contour Aerospace, then it has to be sent to the applicant. We have to give 3 months time for the applicant to reply back. And we see, it's right from step 1, everything is starting because it is a new opponent. All the step from step 1 has to be initiated. And finally, again, hearing with Contour Aerospace and Virgin Atlantics was given. And in that case also, 6 hearings were conducted from 2011 onwards. And finally, even the second opposition by this second company was stated that it is not a proper opposition. And finally, Virgin Atlantics was given a patent, stating that we have to, the controller specifically mentioned this wordings, concept level rethinking. It is what has been applied in the particular application. And I come to a conclusion that the seat aircraft seat made by Virgin Atlantics is novel, is inventive, and it doesn't fall under the pre-grant opposition of these many grounds. And it was given a patent finally. So in one case law, I told you patent was refused in Tata Chemicals and Hindustan Unilever. Tata Chemicals patent was refused. In the second case law, I told you the opposition was refused and patent was granted to the applicant and became a patentee. Fine. Uh, this is what with the pre-grant representation, and there is post-grant opposition is pending. Let me not talk too much today, because overloading of information is also not advisable. If at all you are in such a position, then if the chance permits, I will talk about post-grant, because post-grant cannot be filed by any person. Only the person interested can file in post-grant opposition. And who is the person interested? The section 220 as well as the IPAB and codes have given some directions as to who are all the person interested in the case of a post-grant opposition. So let me not talk, not ponder too much about those post-grant opposition details now, since we have come to the end of the session also. I don't have sufficient time to talk about post-grants. And also I feel at this stage, if you are aware of pre-grant, it is more than sufficient, because post-grant involves fees. Pre-grant has no fees, but post-grant you have to pay a fee and then only you can oppose. So not much people who are really interested will pay the fee and oppose. So let's not worry too much about the post-grant at this stage. So pre-grant, we will spoken in elaborate, and I have told you, though you are not doing any research, you can become a party of the patent proceedings. If you feel that some inventions are filed for patent application, and if you feel that it is not worth getting a patent under so many grounds, 11 grounds that I have told you, then you can file a pre-grant representation. No fees, and even plain paper request we take, even form 7, if you are filing, okay, well and good. Even if you're not filing form 7, filing a plain paper, we take into record that plain paper, and all such proceedings that I have told you are executed and decided accordingly. Fine. With this, I put an end to my session, and I also thank the management of Pratyusha and our madam, the in charge of CSC department, coordinator in this particular session, who is the HOD of CSC department, and our Vatmapriya madam, who was interacting with me. I thank every one of you for giving me this opportunity to share some of my knowledge with good participants here, interactive participants, enthusiastic participants, and I feel extremely happy for offering me this opportunity. Thank you. And if there is any questions, please ask me.
Thank you, sir. Participants, if there are any questions, kindly you can post the question in the chat window, or you can unmute yourself and ask.
I hope my session was clear, crystal clear to some extent, because I don't find any messages in the chat box. I not know the reason why. These opposition proceedings are not usually executed by any layman. Only the people who are serious about getting a patent or serious in the patent prosecutions will utilize it. And for you people who are in the initial stages of research, it is advisable to know about these procedures, so that if someone else is opposing your patent, you should know what to be done. That's why I spoke in elaborate under this pre-grant. Hope it will be clear to you, because I took as many examples as possible to elaborate out the complex and legal terminologies as simple as possible.
Sir, there is a question. Sir, could you kindly repeat the 3 sections in which majority of the applications are getting rejected?
See,
this is a question.
Yeah, first ground is that your invention is not having an inventive step. It is obvious to a person skilled in the art. Section 21J or here B25(1)B is the first ground. The second ground is that non-patentable inventions 1F, 25(1)F or section 3. And finally, 1G, not sufficiently disclosed. Section 10(4) or in this ground 1G. Your invention is though an invention, you have not clearly described what your invention is. There are so many ambiguities mentioned. You are not told about step A to step Z. There are some steps missing out, so that a person who are working in the same field on reading your invention is not able to manufacture the particular product. Your drafting is poor. These are the three grounds under which predominantly they object to. It's not that only these three grounds are there. 99% of the applications are opposed under these three grounds, in my experience.
Yes, sir. Thank you, sir. Any other questions from the participants? There is a question, sir. Have you come across any circumstances where third party has raised false objection just to harass the investors?
There are several instances happening like that. Just to delay the grant of a patent, one legible inventor would have come out with a beautiful innovation and he would have filed for patent. And just to delay him from getting a patent, there are so many, we call them as proxies. They file because there is no fees now. There is no fees, so free of cost they can file a pre-grant representation. At such instances, only the controller should judicially act here. We will take such situations. We will see the grounds of opposition. We will see the evidences. If those evidences are not legal, if they are not valid, we will right away dispose of the oppositions. We will give a decision. We will not disturb the applicant at all. We ourselves will decide that it is a proxy just to delay the grant of a patent. He has filed this pre-grant. We ourselves will decide and we will issue an order to the opponent. Your grounds are not valid, so I am not going to refuse the grant of patent to the applicant. The applicant will be free. We will not at all disturb him. Such proxy people are filing a pre-grant. We have seen several instances like that. Just to delay valid person from getting a patent, such oppositions are being filed. Several instances have been done. Controller has got such powers. He would judicially act in such instances and he will ignore those pre-grants. He will not disturb the applicant.
Yes, sir. Thank you, sir. Thank you so much for joining with us today, sir. It was really a knowledgeable, outstanding, really great session, sir. I request you and the participants to enable the video so that we can take a group photo of the session, sir.
Thank you, ma'am. Thank you for giving me this opportunity.
Thank you, sir. Participants, kindly enable your video so that we be taking a group photo. Sir, I would also request you to please stop sharing your screen, sir, so that we'll take the group photo. Dear participants, please. Yes, sir. Thank you, sir. Thank you all the participants. Thank you so much, sir, for joining with us today.